Good afternoon, everyone. Thank you for joining me here once again. It has been quite a long time, but I am really pleased to be able to come back here. Again, for those of you who don't know me, or if this is your first video you're watching on the channel, my name is Andrew Sindler, a very dedicated Social Security disability attorney. So I first and foremost apologize that it's been as long as it has. I normally aim to put new videos up. At one point, I was putting up at least one every month. Then I started running a little short on material, so I had to spread it out a little more and try to combine relevant material. So I started going to like roughly once every 1 to 2 months. This is probably the longest drought I've had in a while. I believe my last video was posted either in November or December. You can probably verify on the channel. But I have dealt with a lot of things, work and personal. Probably the most prominent things being some horrific bouts of illness. This has definitely been one of the most brutal winters I've had. I don't know about any of you out there, but just to name a few, at least that have hit me personally and members of my household: flu, types A and B, pneumonia, bronchitis, ear infection, ear fluid, COVID, and God only knows what else. And hopefully it's all ahead of our systems for a very long time, if not forever. But I've spent a lot more time this winter sidelined than anything else, and the thought of trying to put a video together and a PowerPoint to go with it was the last thing on my mind for a while. But I've missed you guys. Really glad to be back. So we've got a relevant topic with some bits and pieces that I've referenced in prior videos, so there'll probably be some cross-referencing, but I'm very pleased to share this topic with you as my latest video on the channel, which it's hard to believe we're getting close to the 2 year mark on this channel. So I thank you all for sticking with me. Thank you to all the current and newer subscribers. I hope you'll get something good out of this. So without further ado, let me do a screen share and then um, pull up the slideshow for today's topic. And this is one of my rare videos I'm doing in broad daylight in the middle of the day on a work day even. So um, always kind of fun. All right, bear with me 1 second. This should be it. Okay. All right, and let's get the slideshow started. Okay, so the top and I decided this is one of the first ones, even though the background looks fancy schmancy. This is actually going to be one of my least fancy looking slideshows, at least in terms of the bells and whistles where things kind of float into the screen and all those funky animations. I wanted to keep this one a little more simple because the topics are a little complicated. So I figured at least keeping that simple would be the best I could do. So we're going to be talking about an important topic that probably won't necessarily be as relevant if you don't have an attorney. And when you do have an attorney, they're normally the ones that are on top of this fully from the get-go. But it still doesn't hurt to have a better understanding of how it applies and how it could impact your claim. So the topic we're going to be talking about are medical and vocational experts. And to be clear what I'm talking about, I'm not talking about a situation where you yourself are bringing in your own experts. I'm talking about the ones that Social Security works with. So we're going to be talking about various relevant topics pertaining to this, and that's what we'll be covering for today's video. And as we get through it, and then when we get to the end, I think you'll have a better understanding of why this is a relevant topic and why it's very helpful to have a good understanding of it. All right, so I'm always in the way of my own um, credentials here. So this is the first slide I always put on all of my slideshows, especially for those of you who are not familiar with me. Just again, my background information, all you can read at your leisure, of course, but that should give you a good idea of things. And credentials are pretty much the same and growing, particularly in terms of my practice. My speaking engagements, I just got asked for my latest one at the national conference that's going to be held in the fall in San Diego. I'm really excited about that. It's actually on a topic that I have one of my most prominent and popular viewed videos on. So more to come on that in future videos. All right, so let's first talk about the difference between a medical versus vocational expert. in a Social Security claim. So just some general background. Social Security disability claims, as you know, are premised on a person's ability, or in our case, what we're trying to prove is inability to work a full-time job consistently. We all understand that. That's the most basic Social Security Disability 101 concept. It's covered in my very first video I did. So very, very easy to relate to that. So, by the way, I should say, despite what I said at the beginning, these animations somehow were already part of this. I did not actually put them there. So, some slides will have animations like that. Some will just be straightforward. It appears on the screen. So, just wanted you to know. Um, so, how do you go about proving your inability to work a full-time job consistently? Well, there's two components to it, and that's where these experts, quote unquote, potentially come in. So, we have medical experts that or actually, we're not even at the point of experts yet. So on the medical side of things, to prove a claim, we have to show medical records, generally from your treating sources, sometimes from the doctors that Social Security sends you to, as I've covered in my prior video on consultative examinations. But we have to show that these medical records have findings which prove both the nature and the severity of your conditions and impairments. We have to show not only what you've been diagnosed with, but how severely it impacts you in your daily activities, as well as your ability to be able to consistently work a full-time job. Some medical records do a better job of covering that than others. Some are very black and white with objective medical findings from imaging studies like MRIs or X-rays, or from physical exam measurements, strength and weakness testing, range of motion, things like that. Um, and then also mental health limitations as far as maintaining attention and concentrating or focusing, following and understanding instructions, memory, so on and so forth. So the other aspect of what we have to prove when it comes to proving a Social Security claim is the vocational aspect. We have to show that the medical conditions and the associated symptoms and limitations actually prevent you from performing the tasks of any given occupation or vocation. So it's not enough to just say you've got severe medical impairments and you even suffer certain severe and significant symptoms and limitations. We have to show how that translates into an inability to consistently work any kind of full-time work. And again, I emphasize the any kind because, as I've said on certain prior videos, one of the most common misconceptions that I still to this day, 20 years into practice, run into is people coming to me thinking that all they need to do is prove that they can't do the work they've done their whole career, which for some people that can be 20, 30 years or more. And if they can't do that, what does Social Security expect them to be able to do? And in some instances, that may be enough, particularly if you're in an older age, as I talked about in my prior video about those grid rules. But sometimes it's not enough. And sometimes the safest and best way to approach this is very much to just show that no matter how old you are, no matter what other supplemental rules will apply, your conditions are severe enough to prevent you from working any and all kind of full-time work, no matter what that work is. So that should always be your prime central focus. All right, so continuing this discussion. So you might be asking yourself, once you get your medical and vocational proof, shouldn't the claim then essentially be a slam dunk? Well, not if you're working for Social Security. And first of all, as any attorney would tell you, not just with Social Security cases, but with virtually any type of case imaginable, there is truly no such thing as a slam dunk case or any kind of guaranteed anything. Things can always come up that can shock or surprise you, or that can completely throw you off your game, throw you off balance. And, you may think something is not a liability when it actually is. So you always have to be prepared for all possible contingencies that can come up. And believe me, in Social Security claims, contingencies are a regular component of it. At every stage of the claim, as we're going to be talking about on the coming slides, Social Security has their own set of both medical and vocational consultants slash experts. And I put experts in parentheses because that's a questionable terminology. Partly because in many instances, we don't ever get to see, meet, or interact with these so-called experts or consultants. But the bigger issue about it is, the idea of an expert typically denotes somebody that's also going to look at something in a neutral and impartial capacity. And that is certainly the way these particular types of consultants or experts are charged with doing. But the harsh reality is, far more often than not, they will issue findings that clearly don't benefit or support what you're claiming. They support Social Security's stance. They downplay the severity of an impairment, and that negates your disability. And sometimes the strength of those findings from these medical and vocational people is enough to overcome even the most substantial supporting evidence from any other source you may have it from treating doctors or whatnot. So in that scenario, what are you supposed to do? How do you combat this to try to keep your claim in play and keep it to a point where it's in a posture where you still have a good chance or likelihood of the claim actually being approved? Well, you have to be prepared for what they do and know how to fight it. And that's what we're going to largely talk about for the rest of this presentation and the rest of this video. That's really what it comes down to is you have to know and understand who they are and what they do in order to know how to fight back against them if they're going to work against you and not for you. All right, so we're going to start with talking about, move my screen a little further. There we go. We're going to start with on the medical side. We're going to break it down medical and then go back to vocational. So, as I said, at each level of a claim, generally, at least where decisions are being made on disability, you're going to have these different types of quote experts on the medical side. So at the initial and reconsideration levels, we're going to have consultants slash examiners potentially come into the mix. So first of all, at the first two stages of a claim, again, the initial stage when you first apply, and then the reconsideration stage if you get your first denial, your claim will encounter one or two types of medical experts. So the first one are what we call the state agency medical consultants, SAMC, sometimes we refer to them in short. And state agency again refers to the state agency within each state. Every state has one. It's generally referred to as Disability Determination Services, or DDS for short. Some states have a slightly varied name on that, but it's all the same concept. They have these caseworkers that get assigned to your claim to work it up, compile your medical evidence, have you complete the forms like the function and work history report forms that are covered on my other videos, and then also potentially sending you out for these examinations, which we'll get to in a moment. But again, these medical consultants are contractual medical consultants. All they do is review all the medical evidence in the file, and then they issue findings of the claimant's severe and in some instances non-severe impairments that they find based on the medical evidence, what symptoms and limitations they can reasonably be expected to experience, their physical and mental RFC, residual functional capacity levels and limitations. Again, that RFC specifically is on the physical side, anything between sedentary all the way up to very heavy, and then unskilled versus skilled. Also, various determinations on abilities like maintaining attention and concentration or focus, interaction with other people, memory and understanding to be able to follow instructions and carry out tasks. And they make credibility findings associated with such RFC limitations. And lastly, they'll be the first line of quote defense in determining whether or not you meet or equal a listing at step 3, as discussed in prior videos, or if you satisfy a grid rule, if you're at the age where you could satisfy a grid rule, as I talked about in that video. Now, one of the things that's very frustrating with these state agency medical consultants is that their findings are not disclosed at any time during these stages, and at least not in any kind of detail. So if for any of you watching this, if you've gotten a denial letter at the initial or reconsideration levels, you'll notice that you get no detailed information. And the only information you get, if you want to call it information, is on the very last page in the very last paragraph. It'll say something along the lines of you said you were disabled because of, and then they'll list out all the medical conditions that you alleged were severe impairments and the basis for your disability claim. We realize you have concerns about your health, and we recognize that these conditions cause some problems. but we've determined that they are not severe enough to keep you, it'll either say to keep you from doing the work you've done previously as a, and then it'll list one of your prior jobs at step 4 in the past relevant work, or it will say, although we don't have sufficient vocational information on file, we've determined that you can adjust to other work. And that's basically all they give you. So even attorneys like myself can't access the detailed information about how they found the way they did and why at those early stages of a claim. When and if the claim gets to the hearing stage, which is the one that comes after reconsideration, and I'm sure many of you are familiar with my video on preparing for a hearing with an administrative law judge, once it gets to that level, then we suddenly do have access to that section of the claim file to give us that information. And I believe my next slide might talk about that in a little more detail. I apologize. I don't remember it off the top of my head. Let's see what comes up. Okay, so actually, no, so it's really not there. But again, that's where we get a little more detailed insight as to why they found the way they did. And I think I also will talk about that a little more when I get to the vocational consultant information. All right, now the other type of medical quote expert you might encounter at these initial and reconsideration levels is, again, of course, the consultative examiners, the CEs. And as you all probably know all too well, I've got that whole video devoted to talking about that and helping you prepare for those exams. If any of you have any coming up or think you may at some point, definitely watch that video. But again, just to refresh a couple of points from that one, this is an examination that's arranged and paid for by Social Security. It helps further develop the record and the medical findings. Generally, it's done where there's insufficient medical evidence from treating medical providers, but it can also be done for Social Security to try to get a second opinion, usually in the interest of justifying a denial. Findings from these providers are not necessarily dispositive or binding. They can be, whether they're in your favor or not. But again, at the reconsideration and the initial and reconsideration levels, they do tend to be heavily relied upon. And sometimes that can help you actually support a listing or a grid rule. So again, that's not always a bad thing. Although, without going into a lot of detail, I can tell you all, I've had a few recent instances where I did have such findings from these CE reports that did clearly support my clients meeting a listing or a grid rule, and they still didn't find in our favor, or they didn't find fully in our favor. Another story for another day. And again, sometimes, as you see in the final bullet point here, for whatever reason, sometimes a good and supportive CE, even in conjunction with supporting medical evidence from treating doctors, can still result in a determination of non-disability and denying the claim. But developing the evidence you have control over is crucial for the hearing stage too. So anything that happens at these early stages will set things up at the later stages. So it's very, very important to keep tabs on all that. All right, now let's skip to the next part. And this is something I don't think I've really ever talked about in prior videos, but if any of you are at or will be at the hearing stage, it is possible you could encounter this. This does not happen all the time. But sometimes Social Security goes a step beyond what happens at the initial and reconsideration levels and brings in medical experts at the hearing levels. Now, there are generally two types of medical, again, quote, experts at the hearing level: testifying experts and non-testifying experts. Now, I'm going to actually reverse and talk about non-testifying first. So a non-testifying medical expert is a medical provider who either currently is practicing or has previously practiced medicine in some specialty or discipline, but a non-testifying one will not be present at the hearing, either by phone or however. What they will do instead is they'll be asked to answer interrogatories, which are written questions under oath that the judge or whoever's in control of the claim at the time will present to them. It's generally a form, a standard form they use in all cases, but it helps determine, again, whether the person meets or equals a listing. If they don't, it determines their RFC and limitations. And again, this may aid the ALJ in determining disability. Now, when the interrogatories are answered, so the non-testifying medical expert will review your entire claim file of just the section where your medical records are. They won't review any sections of the claim file that contain non-medical records or other documents, just your medical records. Now, of course, nobody's looking over their shoulder, so we don't know what they're looking at, how detailed they are, how thorough, and if they're taking notes. We don't know if they have everything that's in the file, if it comes through clearly, because it's all presented electronically. But this is theoretically what they're supposed to do. Once they've answered the interrogatories, they get entered into the record as a proposed exhibit, and then the ALJ is required by law to make what's called a proffer of them to you. And if you have an attorney, it goes to the attorney. But basically, it's a letter that says, we have just received the following new evidence that we're proposing to enter into the record. You have 10 days from the date of the letter, which usually comes 5 days in, like many things, so it doesn't give us a lot of time. But basically, it gives us the option to respond to them, to object to them, and move to strike them if they're not reliable. We have the right to compel the non-testifying medical expert's testimony um, at the hearing in order for them to be cross-examined in real time. We also have the option to submit our own interrogatories to the medical expert or request any other action that is allowed to be taken. Now, one thing to be aware of with this proffer is that if a judge doesn't either make the proffer or doesn't afford you whatever you've requested in your response to the proffer, that's an automatic appeal ground by itself. I've had several cases that have actually been overturned on that basis. So that's one thing to keep in mind. Another thing to keep in mind is, obviously, the only time it's necessary to do any kind of affirmative response to them is if they're not favorable to you or the attorneys watching this, your clients. So if you get a set of interrogatories that downplays the severity of your client's impairments, or if it even questionably, if it says questionably that they even have the impairments they're complaining of, then of course you not only want to respond to it and attack it for what it is, but you want to be prepared to call out the medical expert's nonsense too, particularly if it seems like they're kind of one of the, for lack of a better way to put it, hired hands that Social Security engages with. Again, these people are supposed to be neutral and impartial, just like the consultants and examiners at the initial and reconsideration stages, but we know that's not always the way it plays out. Now, another thing to keep in mind is that a lot of times the quote experts that they use in the non-testifying manner of just completing the interrogatories generally do so for a reason, because they don't want to testify and they're not willing to. And unlike a court, they can't really be forcefully subpoenaed into testifying it, even by phone if they don't want to, for whatever the reason. So a lot of times, if you file a motion to compel their testimony and they refuse, then that's the quickest way to get their interrogatory stricken from the record, because if they don't give you the right to confront the expert, then they've deprived you of due process and they can't rely on that expert's testimony unilaterally, or not testimony, but under oath written answers. So that's something to keep in mind as well. And I'm not posting it on here, of course, but if any of you who watch this ever are interested in learning more about this, or even seeing a form that I use in response to these interrogatories, including the interrogatories that I typically provide myself, because the ones that Social Security uses, the standard form, never goes into any significant detail, and it doesn't really even call for these medical experts to do so. Some do a better job than others. It's a very subjective process, but many of them will do the bare minimum, as bare bones as you can get. And the only time that doesn't really matter is if they check the box saying they meet or equal whatever listing, and then they support it with evidence in the record. And by the way, another frustrating thing is that on the rare instance that you do get very supportive interrogatories from one of these doctors, sometimes you get a really stubborn or obstinate, difficult judge that still won't accept them, or that'll find a way to work around them. I've had experiences where I've had really favorable interrogatories from one expert, and then, or even a favorable consultative exam, and then the judge or decision maker goes and orders another consultative exam or asks another expert to do interrogatories because they're just not happy that they didn't get the responses they were hoping for. It's atrocious, but that's why you have to really stick on top of it. And The more you get in your favor, the more you can say there's substantial evidence to support disability. Now let's talk about the testifying medical experts, which are more often than any of the others the biggest thorn in our sides. So these again are impartial medical providers, usually either currently practicing medicine somewhere or previously practiced, again, in some specialty or discipline. And again, with no prior knowledge of the claim and no prior interaction with you as the claimant. They provide live testimony at the hearing to help determine, just like what's in the written interrogatories, what the severe impairments are, whether they meet or equal any of the listings, the person's RFC and limitations. And again, this may also aid the judge in determining disability. Now, the process for how it works, because again, this is not covered in my ALJ hearing prep video, but the ALJ will ask the initial questions, almost like a direct examination, call your first witness kind of thing. And their questions will pretty much mirror the questions that are in the interrogatories. They're just being asked verbally under oath. Um, there are judges that, if they're more interactive and are actually using the medical expert for a good purpose and trying to help get the claim approved, that they will actually ask specific follow-ups based on the answers that the medical expert gave. But some will just literally stick right to the script and say, yeah, we're just going through the motions. So once the ALJ's questioning is done, then the claimant or claimant's attorney may cross-examine him or her. And there's no limit on the time or the questions that can be asked. And this is not intended to be a legal strategy video like that, where I can give you specifics on how you should approach it. And there really is no clear blueprint. Every expert and every hearing and every claim is different. There is a little bit of a baseline approach that, again, if any of you ever want to contact me offline to get any kind of assistance or advice on this, I'm glad to provide it. And it's a very much work in progress. I mean, I still learn as I go different techniques that help with a testifying ME, because as you see here, they're a mixed bag. Some will clearly support disability or go out of their way to try to find a way to do so, and others will go out of their way to oppose it. Some are just that stubborn, whether they just know they need to come out for Social Security more often, or whether that's just their nature. It's like, nobody comes to me disabled. They may have medical problems. I'm going to cure their problems, make them better people. So, um, it really does depend. And you don't get to choose your medical expert. The judge chooses it unless you have some kind of clear conflict of interest, or you can show some kind of prejudice or bias. You really don't have any basis to say, I don't want this expert testifying. It's not like a regular lawsuit where each side gets to choose their own experts, but that's another story for another day. Now, unless the medical expert has indicated that a listing has been met or equaled, which generally, as long as a judge will accept that at the moment, will stop the hearing and award the claim for benefits immediately. And unless they've given testimony on symptoms and limitations that clearly supports disability, the cross-examination itself must delve deeply into the record to show if the ME has not thoroughly reviewed it, which a lot of times you can show. Sometimes it's as simple as asking a question of um, asking them if they would agree that your client, or you, if you're doing it for yourself, have such and such symptoms and findings. Now, if they say yes, then you've gotten them on record admitting something that's in the file that supports your claim. If you get them saying no, and you can point to them in the record where it does show that, you can call their credibility immediately into question by saying, how thoroughly did you review this? If you're telling me you didn't even spot something as obvious as this kind of finding in such and such record on page so and so, that I'm pointing out to you right now. And a lot of attorneys would actually even say never to point the expert where it is. Ask them if they reviewed it and say, would you agree the record shows blah, blah, blah? If they say to you, or if the judge even asks, where in the record are you referring to? You're not technically required to tell them that. If on a cross-examination, especially, your response can actually be, even though this may sound a bit smug, sometimes this is the way you have to play the game, your answer can simply be, it's not my job to tell you where. If you actually reviewed this record, you should know where it is. So, sometimes that works in your favor as well, and in many instances has led to the testimony of these MEs being tossed or at least not given any significant weight or credit. Um, Also, trying to get the ME to admit under oath limitations that would clearly be work preclusive limitations, such as excessive time off task because of their symptoms like pain or fatigue or mental health issues, or how frequently they'd be absent from the job because of their impairments, the side effects of medications, how often they'd have to go to doctor or hospital visits, and so on and so forth. I've successfully gotten claims approved on the basis of getting an expert to admit under oath, even when they didn't volunteer it themselves on direct examination, that my client would clearly have the types of impairments where they're going to have bad days, and those bad days are likely going to lead to either they can't focus on the job at hand, or they're going to call out sick, they're going to leave early, they're going to come in late. And if I can get them to admit that it's going to happen at least one or two times a month on average, that's usually enough to say that's work preclusive, because generally no employer is going to hire someone and take a chance with those kind of limitations. Final thoughts on medical experts at the hearings. Whether you've got a testifying or a non-testifying expert, medical experts can make or break a claim if you let them. Know when they are testifying or supporting a claim, and make sure to clearly point it out and alert the judge if need be. If they do provide the negative testimony or interrogatory responses that we see much more frequently than not, those need to be attacked as unreliable and not supported by substantial evidence. And you can't be afraid to get down and dirty with them sometimes. And sometimes it actually means arguing with them, but I emphasize should always be respectful and courteous arguing, never like yelling or screaming or calling names or anything like that. Nothing like you've ever seen in any kind of movie or TV show where on cross-examination an attorney's trying to break the witness down. Especially medical experts won't typically be broken down like that, but you need to stand your ground to establish the true limitations a claimant has, as supported by the evidence of their treating doctors that know them much better than some independent quack that comes in and looks at their records one time and concludes that the records aren't reliable. Sometimes also pointing out where getting them to agree a treating doctor is going to be in a better position to know the specifics of a person's impairments and symptoms and limitations versus somebody that just comes in and looks at those records. So they're, kind of almost getting them to admit that their opinions are not as valuable and shouldn't be weighed as strongly as the treating doctor. And again, you can establish technical grounds for appeal if a claim is denied on the basis of a medical expert's testimony or interrogatories, particularly if the ALJ, again, doesn't consider or allow the response you gave to the proffer, particularly if you demand that the expert be present to testify or if you want your own interrogatories sent to that expert. So there's probably a lot more I can go over about this, but I'm hoping you're all kind of getting the gist of it by now. So without further ado, let's turn the tide to vocational experts. A lot of my colleagues, by the way, will never refer the ones that testify at the hearings, which I'll be getting to, and I know I've covered a little bit in my prepping for ALJ hearing video. But a lot of them will never, the judges refer to them as vocational experts. Most attorneys refuse to call them experts. They call them witnesses because they don't trust that what they're providing is expert level testimony. And in some ways it probably isn't, but I won't go there for the purpose of this video. But let's start again with what we see at the initial and reconsideration levels with these vocational consultants. So again, just like the medical consultants, these vocational consultants work within the state agency. They're not they're contractual. They don't work for Social Security, and they may or may not have their own vocational practices or businesses. But again, their specialty is what jobs exist in the economy, the RFC and skill levels of all those jobs, and what employers will and will not tolerate as far as limitations and other accommodations needed to perform the jobs. So at the initial and reconsideration level, the vocational consultants first will classify the claimant's past relevant work, if there is any, and probably, again, seen my previous video about that with that 5-year look back rule. But this is also where, I can't emphasize this enough, that work history report form, which I also have a video on, is so vital to make sure you complete it accurately. They will also determine the medical consultant's if the medical consultant's RFC allows for the person to return to their past relevant work. If it does, then that's where the evaluation ends and they deny the claim on that basis. Again, it's step 4 of the 5-step process. If there is no past relevant work, or if it's not indicated they can return to it, then they will determine if there's other work that exists in significant numbers in the economy that the claimant can do in spite of their RFC and limitations. Now, again, significant numbers, which comes up more so at the hearing level than these prior levels, because you never get to see until you get to the hearing level how these vocational experts found what they found. And if they're saying there's other jobs they can do with supposed significant numbers, you don't get to know what those are until you get to the hearing stage. So you have nothing to directly fight against, unfortunately. So, um, but the concept of significant numbers is the numbers that are given are generally national numbers. This is how many of this type of job exist in the national economy. And there is some debate because it's a little bit subjective about what technically constitutes a significant number, because the number itself is one component of it, but sometimes the job or type of job or occupation is another. So to say that a certain number of job A is significant, job B may not be the same case, even if it's the exact same number. So there's a lot of debate about that. There's a lot of case law in the different jurisdictions across the country that say different things, some more favorable to claimants than others. But knowing the numbers and how the numbers were derived, which I'll get to in a moment, is pretty vital too, because they can't say that you're capable of going back to work if they cite a job that there's very little of in the national economy, and whatever that means when you say there's little of. But that's basically what they do at those levels. Now, just like, again, as I referenced before, the state agency medical consultants, we can't see that part of the claim file until you get to the hearing level. And sometimes that's a vital issue, because what you will know before you get to the hearing level is if the claim was denied on the basis of saying someone could return to their past relevant work at step 4 of the sequential evaluation process. You can assume this, but you don't know for certain until you see it in you see the proof in the pudding. If the vocational consultant misclassified the past relevant work as something other than what it actually is, or misclassified certain aspects of the work, sometimes that can make a difference. And I've had some claims when I've gotten denied at initial, when I go to the reconsideration stage, I immediately realize something went awry at the initial stage with the past relevant work when they think my client can return to it, and clearly they can't. So a lot of times I can personally get with the DDS caseworker and make sure that they know that I'm arguing that that the vocational consultant did not classify the work properly. And again, there's not much that can be done to control or oversee what they do at this stage, but getting with the caseworker is pretty vital, because they actually are the first line of defense with that type of situation. And sometimes they can actually note it themselves without even consulting with the vocational consultant. But again, it is pretty vital to make sure that work is being classified correctly. All right, now one of my least favorite and probably most contentious topics, at least among my colleagues and I, these vocational witnesses or experts at the hearing levels. And again, the only video I've really ever devoted to this is my hearing prep video, but just going to delve in a little bit deeper, not too deep, because again, especially if you go to a hearing and you've got an attorney, this is not anything that's going to concern you. You're not going to say or do anything during this portion of the hearing. But to have a slightly better understanding of what they do and how it gets combated, I think is important. So again, what they do is largely covered in that prepping video, but quick cheat sheet here. They're neutral and impartial contractors paid to be there by Social Security, have no stake in the outcome. They get paid no matter what, and they're not necessarily trying to stop you from getting your benefits. They are generally vocational counselors or some kind of professional who specialize usually in placing injured workers in jobs or helping develop their skills to get them placed, and knowing the job market, what jobs exist. And then questionably, and I emphasize the word questionably, as I'll get to in a moment, how jobs in the current market are currently performed, and also questionably how many of those jobs currently exist, coming back to the significant numbers issue. Now, again, their testimony is guided primarily by the judge's questions first, with the different hypotheticals. Assume a hypothetical individual of the claimant's same age, education, and work background with the following limitations, so on and so forth. Is this person capable of returning to their past relevant work? If not, are there other jobs this hypothetical individual could do? And then the vocational expert gives an example of three types of jobs, what the RFC and skill levels are, SVP levels as we refer to them, and how many of those jobs exist. And then the attorney or claimant can cross-examine the vocational expert. And again, there's a lot of question marks, which I'm going to get to in a second, about the testimony they provide. So first, just to mention this, a new ruling that went into effect this past January, it's SSR, Social Security Ruling 24-3P, actually lets vocational witnesses off a bit easier than they used to. So it typically used to be that vocational experts, if they wanted their testimony to be relied upon for a decision, one way or the other, but generally it was a bad decision that would deny a claim, they had to give specific information about what they testified to and how they came up with what they testified to. But this new ruling actually makes it a bit easier, that takes some of the burden of what specifics they do and don't have to go into about how jobs are currently performed versus how the Dictionary of Occupational Titles, or the DOT, says they used to be performed, or the sources and methodology that they use to calculate the numbers of jobs to determine if the job numbers are in fact significant. The cross-examination that a lot of us attorneys have to do actually has become much more involved, but it's also much more vital, because this new ruling, among other things, says that if we don't raise certain things during the hearing, we've waived our right to raise them on appeal at higher levels beyond the hearing. So it's more vital for us to delve into determining proper and reliable methodology and sources of the job numbers that these vocational experts are identifying, and how they calculated them, since they are not mathematicians or statisticians. Um, we also are now charged with really delving deeply with some of these vocational experts about the jobs they identified, as to whether or not they are reliable, if they're no longer performed the same way that the DOT, which was created, by the way, in the 1970s, quite an era ago, says they are. I reference in the end of this second bullet point, emergency message 24027. You can look that up, Google it online, you'll see what it's about. So there's a whole slate of jobs which are primarily in the sedentary, unskilled uh, range. And these particular jobs, which have been cited to many, many times over the years by many, many vocational experts, if you look up these same jobs by their DOT numbers in the DOT, which you can also do online, you would actually see that the descriptions, which haven't been updated in many instances since the 1970s, maybe 1980s, are clearly not the way these jobs, assuming they even exist in the first place, are performed currently. So a good example, one of the most popular ones that comes up regularly, document preparer, which is historically indicated as a sedentary, unskilled job, basically involves certain duties and tasks, such as microfilming documents, putting them on microfilm or microfiche, and basically using a typewriter to type things out, label things, handwrite, label things. And it became so laughable that a whole slew of my colleagues and I started calling that out, saying, is that really the way this job is currently performed, as the way you're citing to it? Because we all know in this day and age, when was the last time you saw anyone using a typewriter for their actual work, or handwriting things out if they have to label things? When was the last time you saw somebody working with or putting something on microfilm or microfiche? It's laughable. It's truly laughable. So some of these vocational experts really have dug their heels in and still said this is still the way these jobs are done, and you still run into these things. Many of them have backed off a bit and realized, yeah, the job's not quite performed the same, but I can still classify it as unskilled because the even where you're working with computers now, where you weren't in the 1970s, it's not rocket science to be able to learn how to do it, but it is still a skill. So sometimes it does, pave the way for us to argue that a job that may have previously been considered an unskilled job with the advent of technology is now very much a skilled job. And if you're saying this person can't do skilled work, then how can you say they can do this job? Um, One thing I will say, this final bullet point here, at its core, effective cross-examination of a vocational witness, in my view, and I've maintained this view for a long time, I'm probably somewhat in the minority with this view. A lot of my colleagues wouldn't necessarily back me up on this, even though secretly they probably do also agree with it. Um, Effective cross-examination still revolves around proving that whatever the claimant's well-established medical conditions and impairments are, and the resulting symptoms and limitations they have, those limitations would not allow the claimant to consistently work a full-time job. That's really what it comes down to. And sometimes I get a little hybrid of that. It's not just about proving that, hey, I know you're not the doctor or medical expert any more than I am, but you would have to agree that if my client can't do blah, 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 and blah, 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 is there really any job they could actually perform? And I can't really ask it that way, but I know the vocational experts kind of read between the lines and see eye to eye with me on that. But sometimes I can slip things in that kind of let the vocational expert insinuate something to the judge. I'll give you a good example. So a lot of times I have clients that have significant physical limitations. A lot of times it's something involving their back or their knees or their hips or whatever, such that both standing for long periods of time and sitting for long periods of time is not really possible. So a judge will put together a hypothetical question for the vocational expert, but it'll have a limitation that includes something like this. Um, let's say it's sedentary work, which is still mostly sitting during the day, but the person still can't sit for long periods before they have to stand up and usually move around. But the hypothetical will sound more like this. This hypothetical individual could perform at the sedentary occupation level, sitting 6 hours total, but they cannot sit for more than 30 minutes at a time. And every 30 minutes, they're going to need to stand up for 5 minutes, but they can still continue to remain on task and complete their work. Well, there's two problems with that specific notation. The first one is if the person has to shift positions every 30 minutes, the implication is they've got significant pain in some part of their body that sitting for that long is not going to be realistic. And the pain is what necessitates having to shift the position to standing and then vice versa. But more importantly, and this is the reality of it, I've demonstrated this for people many times. I'm sitting here at my desk. I've been sitting the whole time I've been doing this video. If I start getting cramped in my low back because of a medical condition or whatever it is, and I need to stand up to try to stretch it out because it's getting painful and stiff. Me just doing this, standing like this, is not going to be sufficient to relieve that pain. I'm usually going to have to move around, and that means I have to move away from. So if I'm trying to record a video here or work on my computer, I got to move away from it. So I can't keep doing the work that I was doing every time I stand up. But more importantly, let's just say I didn't even have to move around, but just the act of standing because, ooh, I'm in pain. You can see me wincing in my face as I'm doing this. In what universe does a rational person believe that I'm in the middle of typing something. I'm in the middle of working in a workstation, putting something together, inspecting something that I can continue typing or doing what I'm doing as I'm trying to stand up to relieve pain that prevents me from sitting for more than that period of time. So the assumption that the person only needs to just stand up every 30 minutes, but can just keep right along working without any interference is not a realistic viewpoint. That just goes beyond human nature. And usually I can call out a vocational expert with this by asking a question of cross-examination of, Sometimes I go as deep as, in your experience, if someone needs to constantly shift positions from sitting to standing, they're usually in pain, correct? And you would agree that pain can be a very big interference with their ability to focus on the work they're doing, no matter how simple or straightforward it is, correct? But then I'll usually go more specifically into, if the hypothetical individual, when they shift positions from sitting to standing, it's not enough to just stand up. They have to move around and walk away from their workstation or desk. Are they going to be off task each time they do that? Yes, they are. Are they going to be off task too much during the workday besides their normal breaks that an employer would be able to keep them on? Yes, they're going to be excessively off task. And that's how you combat that. I mean, I believe me, there's a lot more examples I can go into with sitting, particularly when I have clients that have really significant medical problems with their back, let's say, or knees or hips. Most of them not only have difficulty sitting, but even when they do sit for whatever period of time they do, they have to sit either reclined or with their legs elevated up. And there's not a single vocational expert I've ever cross-examined on this point that said differently, that if that's a requirement, there's no way they can get any work done. Not just because of the pain and because of the fact that that's an accommodation, but just mechanically, scientifically, the minute I start reclining and the minute I start putting my legs up, as you can see, just look at your screen. See how much further away I'm getting from the screen, which equally means my hands are and arms are too far away from the keyboard to keep typing and doing the work on the computer. Not going to happen. So that's another thing that I use to combat this as well. All right, some final thoughts here. While medical and vocational experts, again, are always part of a claim in some fashion at each level, they don't have to be a bad part of it. Proper preparation and planning is crucial. Medical experts and vocational experts can most certainly work for you and not against you if you figure out the way to make them work that way. All right, as always, if any of you ever have any questions, phone and email and even text are the best way to contact me, and I'm always happy to help. With that, stop the screen share. I want to thank you all very much. It's been a long journey on this video, and it's been a long time between the videos, but I really appreciate everybody's patience on this, and I will look forward to seeing you for the next one, hopefully in the next couple months or so. I'm working on some new topics that are relevant, and we're definitely going to address those. Thank you, and have a great day and weekend.